Welcome, everybody. Thanks for joining us. My absolute pleasure to introduce Alan K. Goldstein. He's going to be doing our special presentation on making the law work for 21st century ports. Alan has been helping port authorities in the maritime sector navigate the complex mix of issues and regulations that affect operations for over 35 years. Specializing in maritime law and the interfaces between waterborne and land-based transportation of goods and services. Mr. Goldstein is based in the San Francisco Bay Area and is admitted to practice in California, Illinois, Missouri, and numerous other federal jurisdictions. His full profile can be found at alankgoldsteinlaw.com. And just one little housekeeping, if you have any questions, you can put them in chat, or then we'll use the little hand icon afterwards, and we'll get back to the gallery view for any discussion. Alan, over to you.
Thanks very much, Jane. As I get ready to speak, I'm reminded of an old Jerry Seinfeld joke that goes like this. A poll was taken to find out what people's greatest fears are in life. Death came in second. You heard me correctly. Death was number 2. You know what was number 1? Public speaking. So in other words, at a funeral, more people would prefer to be in the casket than up on the stage giving the eulogy.
Very good.
I can tell you that I do not subscribe to that order of preference. I'm delighted to be here speaking with you, and my hope is that our conversation will be beneficial to you, and that when we're done, you won't wish that I had been in a casket rather than on a public platform speaking to you. I appreciate Jane's kind introduction. As Jane said, I'm Alan Goldstein. I've spent most of my professional life as a maritime lawyer, and I've devoted significant time over the last several decades dealing with issues that port authorities and businesses that operate in ports need to address. It's no secret that this is a challenging time for ports and port authorities. COVID-19, geopolitical events, trade imbalances have brought disruption and uncertainty for us. With the expansion of the Panama Canal, ships are getting bigger, and bigger ships need bigger berths and deeper drafts. A desire to make operations more efficient suggests the need for greater automation. And the recent passage of the U.S. Infrastructure and Jobs Act offers new opportunities for port growth. But port growth near urban centers may conflict with neighboring interests, environmental and zoning restrictions, and other regulatory constraints. And the efficiency that automation offers may be impeded by union contracts that require certain levels of manpower and that limit the length of a workday. Meanwhile, the transition of port business from a paper-based model to a digital and electronic model continues unabated. But unfortunately, the wonders of cyber technology can be a bit of a double-edged sword, since connecting electronically to the whole world invites into our midst some bad actors hiding in distant places who may disrupt our operations with a few keystrokes on their computers or malware that they insert into our computers. Put simply, the good old days of a fence and a guard at the gate to secure port property are, of course, of no protection against cyber attacks. In the relatively short time we have today, it would be impossible to address all of these concerns and how the law can help ports mitigate the risks they face and confront the challenges they face. But we can make a start. Some may think the law is a necessary evil, to consider only when cargo's damaged, vessels collide, or a longshoreman gets hurt. But I would suggest to you that the law is an essential tool to help ports achieve their goals and meet 21st century challenges, including expansion, especially if you examine your legal house and make sure it's in good order before rather than after difficulty ensues. Virtually every challenge that ports face includes a legal component. And much of the legal piece of your business puzzle concerns how the choices you make about what to say in contracts and other legal documents will affect your operations. Contracts aren't meaningless boilerplate. They're not an unpleasant chore to gloss over so you can move on to other things. On the contrary, how you negotiate and draft contracts affects who bears the risk of doing business, your rights and obligations, whether and how you can expand, and whether you can effectively address the claims and issues that inevitably confront a business as complex and diversified as a modern port. Accordingly, it makes good sense to be sure your contracts work for you, not against you. Let's talk about some specific examples. When a port authority hires an operator to run the port, or leases port facilities to an operator, or engages a provider to render services within the port, almost invariably, the written contract with that party will include promises about insurance. Who has to buy insurance? What coverages have to be purchased? Whose insurance will be primary? Limits of liability. What underwriters the insurance can be purchased from? Waivers of subrogation. Who are going to be the insured? And a host of related issues. I've seen port contracts that use the same insurance clauses that they used 10 and 20 years ago. But the nature and scale of business risks changed dramatically over time. 20 years ago, no one worried about cyber risk. 10 years ago, what seemed like a reasonable limit of liability for bodily injury or pollution claims may be inadequate today. My point is that ports are dynamic, like the world around us. And as a result, what you agree to for insurance protection in your contracts with port operators and other vendors needs to change over time to meet new and different risks. In a changing world, we cannot sit idly at anchor and realistically hope to get where we need to go from a business or a legal perspective. Insurance clauses in contracts generally try to minimize and transfer financial risk, preferably from your port to someone else who reasonably should protect you against dangers that their operations in your port create. Accompanying the insurance clause typically is another essential clause that transfers risk. That's a defense, indemnification, and hold harmless clause. In layman's terms, it's a clause that requires one party to protect another party against losses, claims, and lawsuits under circumstances that the contract specifies. For example, I would expect that if a port authority contracts with a warehousing company or a stevedoring company to operate its port facilities, that the contract between the two is going to require that operator to defend, indemnify, and hold the port harmless if someone gets hurt or killed or property gets damaged during the company's operations and it leads to a claim or a lawsuit. But these defense, indemnification, and hold harmless clauses are not, so to speak, one size fits all. Important variations can be applied depending upon the parties' respective bargaining positions and what they consider to be a reasonable division of risk. For example, is the port operator required to defend, indemnify, and hold harmless the port authority when claims arise from its operations, even if the port operator was not at fault? Or will the obligation exist only if the operator acted negligently and that negligence caused the loss? What if the loss or accident occurred because both the port operator and the port authority were at fault in some fashion? Is the port operator obligated to defend, indemnify, and hold harmless the port authority in that instance? And if so, is the operator only responsible to the extent of their own fault? Will the port authority have to bear the loss to the extent that the port authority's fault caused part of the loss? And what about this obligation to defend, indemnify, and hold harmless? Is it unlimited, or does it have some cap or ceiling? These and related questions are important to consider because depending upon how we negotiate and draft this defense, indemnification, and hold harmless clause in the contract Your port authority may be wholly protected against loss by the port operator, partially protected, or not at all protected. In short, when I, as a lawyer, counsel my client about what these clauses should say in a contract, it's an important exercise to add value and reduce risk. And it's something we often do in conjunction with the port authority or the port operator's marine insurance broker, so that these related issues of insurance, defense, and indemnification are addressed in concert in a thoughtful and coordinated fashion. There are other clauses in the contract that help transfer or minimize risk, or at least should, including, among others, clauses that limit what damages can be recovered, clauses that require prompt notice of claims and set time limits for asserting claims, clauses that state whether attorney's fees are recoverable, and clauses which address dispute resolution. In other words, if we, the port authority and the port operator, get into a dispute over some loss and we can't informally work it out between ourselves, where are we going to go to get this resolved? Are we going to arbitration? And if so, where and under what rules? Are we going to court? And if so, where and according to what law? Here too, what we're trying to do by negotiating and setting forth these clauses in the contract is to try to afford some protection against future problems and to try to create some predictable outcomes if and when something goes wrong. It's something akin to a contractual equivalent to a ship battening down the hatches, something you should do in advance of a legal storm, not after the storm is upon you and it's too late to change the contract wording to avoid getting thrashed. One of the many concerns facing ports today is what to do with the shipping containers that are piling up because the U.S. is importing more goods than it's exporting. To paraphrase that old Roach Motel commercial on TV that some of you may have seen, containers check in, but they don't check out, at least not in any timely fashion. Take a look at your contracts. What, if anything, do they say about demurrage on containers? What do they say about who's liable for that demurrage and how much it is? And learn from experience. If you run into problems with container demurrage, try to negotiate for extended free time if you're an operator in a port. If your experience there suggests that demurrage costs are likely to be a problem for you. Please keep in mind as a general matter that contracting for a port authority or a port operator should not be a cookie cutter approach. Cookie cutters are great when you want every cookie to look the same. But contracts with different parties for different purposes in a port involve nuance and distinction. They shouldn't be punched out of a mold, one after another exactly the same, when the risks and circumstances are not the same. Of course, you may have certain standard terms and conditions that you like to use as a general matter. But as circumstances and contracting partners change, adjustments become necessary. Your lawyer should advise you about your legal rights and obligations and help you use the law in those instances to achieve your business goals, including sound risk management. But ultimately, you, not the lawyer, will decide whether a particular contract and a particular level of risk are acceptable. Let's talk for a moment about regulatory constraints. Benjamin Franklin said nothing is certain but death and taxes. If the inventor of bifocals and the lightning rod were alive today and working in our industry, he might say nothing is certain but death, taxes, and regulations that affect and constrain port operations. CERCLA, the Jones Act, the Shipping Act, Clean Water Act, the Rivers and Harbors Act, FELA, the Family Medical Leave Act, the Americans with Disabilities Act, and other federal, state, and local laws prescribe what port authorities and port operators can do and how they do it. I mention this not to complain. Some of these laws advance important social and commercial goals. Rather, my point is that when you operate in a tightly regulated environment, as you do, with oversight by various government agencies and departments, it makes sense periodically to check whether your operations comply with the law and to consider how best you can expand or modify your operations consistent with regulatory constraints. Try to perform that review in advance to minimize risk, not simply after you're beset with legal problems. The old adage about an ounce of prevention being worth a pound of cure applies to 21st century ports. In my experience, port authorities and port operators can save a lot of money in the long run on legal exposures by spending a little money in the short run to make sure their legal house is in order. Let's talk for a moment about the U.S. Infrastructure Investment and Jobs Act. Sometimes people tend to think that laws and regulations only constrain us, but laws can create opportunities too. And that's really what the new U.S. Infrastructure Investment and Jobs Act is about. According to the Maritime Administration, the law invests more than $17 billion in port infrastructure and waterways. The primary aims of that spending are, number one, needed repairs and maintenance. Number two, reducing congestion to strengthen supply chains and eliminate bottlenecks to enhance efficiency. Number three, investing in environmentally friendly sources of energy. And number four, creating jobs. MARAD will have several $100 million per year for the next 5 years for projects that fall into one of four categories: loading and unloading goods at port, movement of goods into, out of, or around a port, projects for resilience, such as those addressing rising sea levels, flooding, extreme weather events, and natural disasters, and number four, projects that mitigate pollutants or greenhouse gas emissions. So how do you access some of these funds to support a project at your port? That's a complex undertaking that goes far beyond the scope of this short seminar, but I would suggest a couple of starting points for you. First, whatever your project is, you need to be able to explain persuasively how it will help accomplish the goals of the law. And in making that presentation, you should demonstrate its significance, not only on a local level, but preferably also on a regional and possibly a national level. Of course, your ports are located in specific places. In that sense, they're localities, but they have an impact beyond the Port of Long Beach or Oakland, California, Redwood City, Seattle, Washington, wherever you may be. And part of what you want to do in making the pitch for these funds that can help your port is to explain to the people controlling the purse strings how it is that the project you're proposing at your port will have an impact, not just locally, but regionally and perhaps nationally or internationally. How do you connect to the rest of the United States? How do you connect to the world such that making your port better, bigger, more efficient, more capable will benefit the nation generally? After all, the broader the potential impact of your project, the broader the potential level of support you may gain from elected officials and other influential people and associations. Second, in order to do this effectively, to make a good pitch, to carry it through, and to get your project accomplished with federal funding, you need to assemble a strong team. Building, expanding, or modernizing a port is a multifaceted endeavor involving design and engineering, legal, financial, and political considerations. Accordingly, you're going to need engineering and design expertise, specifically with regard to transportation projects. You're going to need legal counsel with port expertise and skill. And you're going to need executives or consultants who can reach out to key elected officials and regulators to obtain funding and necessary approvals. It's a challenging and competitive undertaking that demands expertise and thoughtful planning from a team of capable people. Let's talk for a minute about services that ports provide. Of course, ports need to raise money to fund operations. Sometimes that involves charging users of port facilities. But there's a right way and a wrong way of doing that. The US Constitution and certain other laws prohibit port authorities from burdening interstate and foreign commerce. A port cannot charge a fee to a vessel just because that vessel passes through the port area. That would burden or discriminate against interstate commerce or foreign commerce. But a port can charge for services and facilities it provides, such as wharves, landing places, security, lighting, and firefighting. In some instances, that fee for services may be proper, even if a particular vessel does not actually use the service, but is deemed to benefit because the service, such as firefighting, is available for its protection. My point here is that ports need to consider legal requirements when deciding what and how they charge vessels and businesses that visit their ports. Let's talk for a moment about lawsuits. Unfortunately, we live in a litigious society. When things go wrong, all too often, the response is to sue somebody, especially a high profile and substantial entity such as a port or a major port operator. Fortunately, there is some protection from lawsuits for states under common law sovereign immunity and under the 11th Amendment to the US Constitution. This can raise important issues when a port or its personnel are sued, including, among other things, number one, is the Port Authority an arm of the state so as to be entitled to protection as a sovereign or under the 11th Amendment? That can depend on the nature of the port entity and how it was set up. For example, bi-state authorities, creations of multiple states, typically do not enjoy 11th Amendment protection because they're not a state. Number two, if the defendant in the lawsuit or one of the defendants is an individual, let's say a port officer or a port employee, is he or she being sued in their official capacity on behalf of a state actor? In which case immunity may be available for this lawsuit against them, or are they being sued in their individual capacity? In which case immunity will not be available. That's essentially a legal question, but an important one to ask if and when a suit is brought against the port or the port operator for allegedly having done something wrong. On a final note, when lawsuits raise their ugly head, we come full circle back to the contract issues we talked about at the outset. When I'm asked to defend or counsel a port authority or a port operator facing a claim or a suit, one of the first things I ask for are their contracts, so I can see whether they have any contractual protection, either from the party who's bringing the claim or suit against them, or, as we discussed earlier, from a port authority or port operator with which they've contracted as part of a transaction in which one of the things that they required in the contract was protection in the form of defense, indemnification, and hold harmless. It's at this point, when suit is filed against our port or our port authority or our port operator, and we look at the contracts, that we find out whether the port or port operator prudently spent an ounce of prevention at the contracting stage to now gain a pound of cure at the litigation stage. That is my short overview for you. And it brings us to the question and answer session. Albert Einstein said the important thing is never to stop questioning. And I think that's a great approach for ports to better manage risk by constantly asking, what are the risks of doing business and how do we best protect against them? If you have any questions about what we've discussed today or points that are pertinent to the challenges that ports face in the 21st century and how the law might help protect against those risks, I'm happy to try to answer them. Thanks very much for your consideration. I appreciate it.
Great presentation, Alan. Thank you very much. If anybody else has any questions, I have one question here. You mentioned about How do you reconcile saying that contracting should not use a cookie cutter approach when you acknowledge that having standard terms and conditions can be a good thing? Aren't standard terms and conditions cookie cutter?
Jane, you're a tough audience, but there is those two are easily reconciled, and that's this. Remember that standard terms and conditions, like a cookie cutter, are great when you're dealing with the same situation again and again and again. So if I'm a passenger on a cruise ship, the ticket that they hand me that sets forth terms and conditions is going to set forth the same terms and conditions that are on the ticket that they hand you. And that's, of course, their contract with us. But my point is that when you get into, as a port authority or a port operator, negotiating transactions with various actors for things like stevedoring, warehousing, dredging, energy, and any of the many other needs that ports and port operators have, it's important to recognize that there's an exercise of judgment here, and that we want to avoid the situation in which somebody says, oh, I've got a contract from a few years ago. We had something similar to this, so I'll just pull out that contract and we'll do the same thing. Situations tend to be different, and they tend to demand some exercise of judgment to figure out to what extent can we do what we did last time, and to what extent are we living in a brave new world that requires something different.
Okay, thank you.